In today's video, you're going to learn how to legally migrate to the UK. You will also learn how recent changes in UK immigration policies can affect you if you live in the UK. In the studio today, we've got a UK-based solicitor who is an expert in immigration law. Without wasting your time, can you please introduce yourself to the audience?
Hello everyone, I'm Laurentia Kujirafu. Thank you very much for allowing me into your homes, your cars, your offices, wherever you are listening to today. I specialize in UK immigration law, and I hope I'll be able to answer your concerns today on UK immigration law. I have about 15 years experience in UK immigration law, and I hope that will help you today. Thank you.
Thank you so much, Laurentia, for joining us at the Lunch Club. The first question we have for you today is, for someone who is outside the UK, who's considering moving to the UK with their family, what would you suggest is the best pathway for them to achieve their migration dream?
Now, for someone wanting to relocate to the United Kingdom, the best pathway will be dependent on your current circumstances. What I tell people is ask yourself one simple question: why do you want to relocate? So if, for instance, you want to relocate because of family or you want to work, then if it's family, the best pathway will basically be to apply as a spouse of a settled person. If the family member is settled in UK or is a British citizen, for instance. Now, when you make your application, it would be an entry clearance application. You have to provide supporting documents. The Home Office will now consider your application with the supporting document, and then they will decide whether you qualify or you don't. If you do qualify, they will put a stamp in your passport, which is a vignet, and then that will allow you to travel into this country. When you come, they will give you 2.5 years leave to remain to start with. Now, for someone else who hasn't got family in this country and want to just come and work, what you have to do, the best option will be to explore the skilled worker migrant route. Now, with that one, you look for an employer, someone who can employ you and who can sponsor you as well. The reason why I say this is it's not everyone who can employ you, who can sponsor you. So you look for the person who can employ you, who can sponsor you. You go through their process, and then after they are satisfied that you can work for them, what they will do is they will issue you with something called the certificate of sponsorship that will allow you to go and get your visa, to make your visa application. Now, after you've made that visa application, the Home Office will now consider your application to see whether you satisfy the required rules or not. If you do satisfy it, they will now grant you leave to enter as a skilled worker migrant. So it all boils down to every individual and their circumstance.
Thank you very much. Recently, there's been reports in the news about people, especially those that came through the care workers visas. They have been receiving letters from the Home Office giving them just 60 days notice to leave the UK if they cannot find a job with a new sponsor. What would you advise those people in that category? What are their options?
Now, it's very, very worrying. I mean, for you to be there, you receive a letter from the Home Office saying you've got a set number of days to leave the country. The good thing, though, is they give you an option to make another application. What I tell people in that particular situation is that assess yourself, your situation, your circumstance. Do you still want to work as a carer? If you do, what you have to do is look for another employer immediately so you can switch. If not, ask yourself, do you have a family in the United Kingdom? Do you have a spouse who is settled here? Then, of course, you can switch to the spousal category. If not, do you want to study in this country? So you can also look for an appropriate school that can sponsor you, and then you can switch to become a student. But it all depends on each and everyone's circumstance. Everyone's case has to be assessed on an individual basis.
Thank you very much. There has also been reports of delay in the Home Office issuing certificate of sponsorship. For those who are waiting, what are their options?
Now, currently, I think what has been happening is because people were making they are saying fraudulent applications, the Home Office put in place certain mechanisms to limit that. So that has led to some delays in issuing the certificate of sponsorship to these employers. Now, you can't do much about that in relation to whether or not it's anything to do with in relation to getting the Home Office to speed the issuing of those documents. What you can do as an individual is assess your circumstance and your situation. What can you do? You may want to switch to another category. You may want to become a spouse if you have a family as a spouse in this country who is settled in this country. You may, as I've already said, you may try to explore whether you want to become a student or not, or you may want to fill an application form. There are several application forms online which allows you to make an application and then explain your circumstance to the Home Office and say, look, I'm trying to apply for a certificate of sponsorship. It hasn't been issued yet. I'm trying to make my application. So I'm making this application to enable me to extend my leave to remain so I don't become an overstayer whilst I wait for my COS. Now, as to whether the Home Office would issue you something or not, is entirely up to them. It's a discretion they have to exercise, but at least it stops you from becoming an overstayer.
Am I right in saying that that application is something that you can support?
Yes, we do assist people in making the applications, but we always tell them that it's on case-by-case basis. We have to assess your circumstance.
Thank you. If you're seeing any value for what you're hearing now, consider subscribing to the Launch Club. Follow us on all our social media platforms. We want to help people to legally migrate and achieve their migration dream. I will leave Laurencia's email at the bottom of this screen so that you can contact her directly, and she will be able to provide you first-class service. Laurencia, the next question we have for you is that there has been recent reports of changes to the UK citizenship and leave to remain, indefinite leave to remain. Can you please update the audience on what those changes are, please?
Now, I'll start with the citizenship. A new Section 10A has been introduced to the British Nationality Act. Now, with this one of 1981 as amended, now with this particular new introduction, what they've done is they've catered for children born on or after the 1st of July 2021 to European Union nationals. Now, prior to this introduction, as soon as a child is born in this country and the father or mother at the time of birth is settled in this country, the child automatically is born British. However, with the European Union nationals, with this new introduction, what now happens is if a child is born on or after the 1st of July 2021 and a parent hasn't got the indefinite leave to remain yet, but has put in an application, the child will still be deemed as being born automatically British. Now, another scenario is if the parent qualifies for indefinite leave to remain, but have not put in an application yet before the 1st of July, what they can do is they can still apply for a British passport for the child and prove that they satisfy that particular requirement before the child was born, or at least at the point of birth of the child. That is one crucial thing. One important thing I think people should know about the citizenship rules, and that was introduced. That was recently introduced, so it will help people to look at their circumstances. Now I'll move on to the indefinite leave to remain. A lot of changes has occurred with the indefinite leave to remain. One occurred, I think it was in April 2023. Now with that new change, what has happened is before you make an application for lawful residence under the 10-year route, under the immigration rules, normally any form of lawful residence you would have spent under that particular during that particular 10 years would have been counted towards your 10-year lawful residence. However, things have changed. Basically, what they are trying to say is if you spend leave as a visitor, it will not be counted towards the 10 years. If you spend leave to remain as a short-term student, it will not be counted towards the 10 years. So what now happens is before you make your application for being in this country lawfully for 10 years, you have to reassess the years, the qualified years that you are going to use in making the application. That is one thing that people have to take into consideration. The other one is in relation to children or young adults who made applications under the private life route. With that particular one, they were expected to have spent 10 years before they were given indefinite leave to remain. Currently, it has been reduced to 5 years. So if the person is a child or the person made an application as a child or a young adult, once they can prove that they've been in that category continuously for 5 years, they can now apply for indefinite leave to remain. These are some of the changes that has come. Recently, on the 31st of January 2024, they did introduce Appendix Bereaved Spouse, Appendix Domestic Abuse. Now, with these ones, they've introduced them to cater for children as well. And most importantly, with the Domestic Abuse Appendix, it caters for partners and children who may have been left outside the country and like previously couldn't make any application as a victim of domestic violence. Now they've introduced these new rules, so it allows them to make entry clearance applications as spouses of as people who have suffered domestic violence, which is something that is new. So people should also bear that in mind so that it helps them in making their new applications as well.
Thank you very much. So, can I just quickly ask you a question about the European Union who live in the UK and having a child? Yeah. Mm-hmm. So, in order for a child to qualify for British citizen, are we saying that the parents, if they are Europeans from the previous EU countries, the parents will have to have settled status in the UK? Is that correct?
Currently, under the immigration rules, every child born in the United Kingdom, what they do is, as soon as a child is born, they look at the parent's immigration status. If the parent has indefinite leave to remain, or one of the parents has registered as British, the child is automatically born a British child. Now, so the requirement for you to be seen as being born automatically British is that one of your parents should either have indefinite leave to remain or citizenship on the date of your birth. Now, what they've done with these new rules, in relation to European Union nationals, is that they've told them, look, you may not have indefinite leave to remain at the date or on the date that your child was born. It doesn't matter. Once you can prove to us that you've made that application before the child was born, or you can prove to us that before the child was born, you qualified for 5 years for indefinite leave to remain, then we will still consider the child as being born automatically British.
Right, okay. So for someone whose parent is Spanish, they've been in the UK 2 years, they have a child. Is that child automatically British?
No, because that person wouldn't qualify for settled status. You must have lived in the country continuously for 5 years under the EU settlement scheme. Yes, or before that.
Thank you.
You're welcome.
So what about indefinite leave to remain? So what is the process of obtaining? Has there been any changes with respect to the process of obtaining indefinite leave to remain and UK citizenship? That's my next question.
Now, with indefinite leave to remain and UK citizenship, they haven't really made a lot of changes. Now, with indefinite leave to remain, you still have to satisfy the same requirements, the same criteria that you have to satisfy. You have to ensure that you satisfy the English language test, the life in the UK test, if you have not submitted with a previous application before. So it hasn't really changed much. The only thing you have to bear in mind is that under certain circumstances, you can shorten the period, okay, to obtain indefinite leave to remain.
Under what circumstances can it be shortened, please?
For instance, if you become a bereaved spouse or you become a victim of domestic abuse, yes, then you can shorten it. But nothing much has changed in relation to how you make the application and how long it takes for you to do the application.
Okay. Am I right in saying that for someone who is married to a British citizen, they qualify to apply for indefinite leave to remain after 5 years, and subsequently 1 year later they can apply for British citizens? Is that correct?
That is incorrect. It's correct partly, but not fully correct. The reason being that when they get the indefinite leave to remain, they do not need to spend that 12-month period before they can apply for citizenship. Okay. If you are here as a spouse of a British citizen, the day you qualify for indefinite leave to remain, that same day you can apply for citizenship if you've got the money.
Okay. Yeah. Thank you very much for that.
You're welcome.
Go ahead.
Any other person, you have to spend at least 12 months after the date you get the indefinite leave to remain before you can make the application.
Okay, that is good. Thank you so much for clarifying that. What about for those that came on the workers route? After 5 years, do they still qualify for indefinite leave to remain after 5 years?
After 5 years, if they still satisfy the rules, yes, they will qualify for indefinite leave to remain. But those people have to spend 12 months after the indefinite leave to remain has been obtained before they can apply for citizenship.
Okay, that is really, really useful. So is there any circumstances under which someone who is already British, their citizenship can be withdrawn? Can you just elaborate on that? Because this has caused a lot of anxiety, understandably, amongst people, especially in the minority community.
Now, the second, it's been around for a long time. So, the fact that you are British doesn't necessarily mean that you have it for life. Under certain circumstances, the Secretary of State can withdraw it. This is a provision of this particular provision is made under Section 40 of the British Nationality Act 1981 as amended. Now, it was amended by a new legislation that came into effect. I think it came into effect in 2022, the British Nationality Act. Now, with this particular one, what they said was prior to this new this introduction, what was happening is, under certain circumstances, like if the Secretary of State deemed it conducive to public good, that you are a threat to security, if you obtained your citizenship by either fraud or misinformation, they could and they can deprive you of your citizenship. However, there's a process that they go through. The process is simple. The Secretary of State will make an order and let you know that we are going to withdraw your citizenship. This is the reason why we are going to withdraw the citizenship. You have a right of appeal. But with the introduction of this new rule, okay, what has happened with the British Nationality Act 2022, what has happened is that under certain circumstances, very exceptional circumstances though, what the Secretary of State can do is they will withdraw the citizenship, deprive you of your citizenship, but they will not notify you. Now, for instance, if you are out of the country and they can't get to you, they still will deprive you of your citizenship. Now, you would know when you get to the port of entry that, look, you are no longer a British citizenship. You are no longer a British citizen. For that matter, they will not allow you to enter the country. But then they will tell you that you have a right to appeal the decision. So what I tell people is be very, very careful when you are going about your business. Of course, no one wants criminality. You get what I'm saying? And it's not right that you should engage in certain things. So if you don't want these things to happen to you, then of course you become a law-abiding citizen, live your life as a law-abiding citizen, do things properly, and then hopefully this particular thing wouldn't happen to you. But the Secretary of State, under certain circumstances, can withdraw the citizenship and can decide not to give notice as well.
Thank you so much, Laurentia. So for parents for a child whose parents are living in the UK unlawfully, and how for the child born in the UK whose parents are living unlawfully, how long can it take before the child get legal status in the UK and at the same time for their parents?
Now, if a child is born in the United Kingdom to parents who haven't got leave to remain in the country, what they can do is, if the child lives in this country continuously for 7 years, they can make an application for the child. Now, normally, they have to prove certain things that it's unreasonable to expect the child to leave the country. If they satisfy the rules, they can apply for indefinite leave to remain for the child. If not, what they can also do is they can wait till the child gets to 10 years. Now, when the child is 10 years old, they can apply for citizenship for the child immediately. Once they can prove that the child was born here, has lived in the country continuously for 10 years, and within that 10-year period, they didn't spend 90 days in any of the 10-year period, in any of the years in the 10-year period, then they can apply for citizenship for that child as well.
Okay, so a child whose parents are living in the UK unlawfully, born in the UK after 10 years of living consecutively in the UK, the parents will be able to apply for citizenship for the child. Is that correct?
Yes, that is correct.
Okay, and the parents themselves, what is the process that they have to follow to regularize their status in the UK?
Now, once the child gets to 7 years, there's a provision under Appendix FM of the immigration rules. It's called the parent route. Now, with that particular one, a parent who has a qualified child. Now, a qualified child is deemed to be someone who was born here and has lived here for 7 years, or who wasn't even born here but has lived here continuously for 10 years. Now, or someone who is British. Now, so if the child was born here or has lived here continuously for 7 years, then the parents now become eligible to make an application as a parent of a qualified child, and they would give them 2.5 years, provided they satisfy all the requirements of the rules.
Okay, and it's very, very important to know that the child must not live outside the UK for more than 90 days in that 10 years period. Is that correct?
Yes, for the citizenship one, yes, it's very, very important, because they always look at continuous residence, continuous residence, continuous residence. So if you give birth to a child, you take the child out of the country for maybe 3 or 4 years and you bring the child back, you can't prove the continuity.
Okay, thank you so much, Laurentia, for the update so far. If you're seeing value for what you're hearing, give this video, you can show appreciation by giving this video a like, leave your comment in the comment section, and subscribe to this channel if you haven't done so. We want to help as many people as possible to achieve their legal migration in the UK and other countries. Laurentia, the next question I have for you is for someone, for example, who came to the UK under the carers rules. They are currently living in the UK. However, before they came to the UK, they graduated from law. They would like to move to convert and be able to practice in the UK as a solicitor. What is the process that they have to follow in order to achieve their dream?
Now, with someone who comes into the country with a law degree, now, what I would suggest they do first and foremost, because the Law Society has got a vast amount of information about how to qualify, I would first and foremost signpost them to the Law Society website. Now, if they go on there, they've got all the routes that you have, all the pathways that you have to go through, what you can do, what you cannot do. If you are able to follow what they ask you to do, then it would assist. However, under certain circumstances, if, for instance, the person hasn't just got a law degree, but is actually a qualified barrister from, let's say, Nigeria, or a qualified lawyer from, let's say, Ghana, then theirs become much more easier in the sense that they already have the qualification, they've already been enrolled or called to the bar, whichever country they are in. So I, for instance, I qualified initially in Ghana, West Africa. Now, when I got here, what I had to do was contact the Law Society. They showed me what to do. Now I had to do a set a set number of exams. Okay, it's called a lawyer's transfer test, the qualified lawyer's transfer test. Now, things have changed since I came here. So the best thing is when you go onto that website, they give you the right pathway to take and you follow the instructions. But it definitely would involve doing an exams, doing some training, and also doing also them being able to assess you in relation to your character, your whether you've got any criminal record and all those things. And your suitability as well to become a solicitor in this country. But the best thing to do is get in touch with the Law Society of United Kingdom, and they should be able to assist you on that one.
And am I right in saying the whole process, it can take up to 4 years to be able to practice to qualify to practice as a lawyer?
Yes, it can. Yes, you are right. It can take up to.
Okay. So what about parents who are living in the UK? They will want their children to go into the law profession. What pathway would you advise for children, for young people that want to study law in this country?
It's an interesting question. The reason why I think it's interesting because my mom wanted me to be a pharmacist, but I chose to do law. Now, what I would tell parents is never ever compel your child to do anything. What you have to do is I will let them know that look, just ask them what they actually want to do. You have to find out what they are interested in. Now, introduce them to things like law books, introduce them to courtrooms. Let them just go and observe a solicitor, a barrister in court, see how they react. Introduce them to law films, let them view all this and see how they react. Now, if they are truly, truly interested, the starting point is working on their exams, their GCSEs. Now, make sure they do very well in those exams. Get them private tuition if you can afford. If you can't afford to, then make sure you are spending time with them as much as possible so that they can improve on their grades. Don't rely just only on the school, that they go to school, they come back, they do their homework, they are okay. No, put in extra effort. Apart from that, ensure that when they move to the A levels, they do very well. They get the very, very good grades, okay, so that they can get into the top schools as well, because that sets them up for whatever they want to do. I always say that you are the sum of the 6 people around you. So if you get them into very good schools, mix them up with very, very good children who really, really are interested in progressing and doing well in life, then of course they are going to influence the child. Now, with that, they are likely to get into the best schools, and then of course the schools will direct them, guide them as much as possible for them to become the best that they can be. But what I always stress on is don't force your child to do something they don't want to do. It should be something they love doing, because it would help them if they actually love what they are doing, not that they are being forced into doing something like that.
Laurencia, it has been a pleasure having you on this show today.
Thank you very much.
If anyone wants to reach Laurencia, her email is very, very easy. It's going to be on the side of this video. You can contact her directly and be rest assured that you will get first-class services from Laurencia. I have been in the UK. This is my 22nd year in the UK now. If you want, there's no substitute to credible and reliable information. If you want to legally migrate abroad, information is the key. Follow this channel, will give you the latest update. Laurencia, I'm very, very grateful that you come around to speak to us, and I'm sure you will come back again to speak to the audience, and it's been a pleasure having you on the show.
Thank you for having me as well. Thank you.
Have a nice evening.
Thank you. Bye.
Bye.